Ready for a deep dive into a tax case with some pretty big consequences for businesses in the Philippines. We're going to be looking at Philippine VAT law today, specifically the case of Commissioner of Internal Revenue versus Deutsche Knowledge Services.
Yeah, this case, it really gives us a good look at how VAT law works, especially when you're talking about zero-rated sales and trying to get refunds.
Right, and our main source for this deep dive is going to be the court documents straight from the Supreme Court of the Philippines, where this whole thing ended up. So we've got Deutsche Knowledge Services, also known as DKS, a company from Singapore with a branch in the Philippines. They're registered to pay VAT, and they mainly work as a regional operating headquarters, doing things like business planning, giving financial advice, all sorts of things.
In this case, it shows just how important it is for companies, even those with what seem like simple operations, to really get a handle on all the details of these VAT rules.
Because what happened was DKS filed to get a refund on what they said were unutilized input VAT amounts from back in the fourth quarter of 2009. And we're not talking about chump change here. This is over 34 million Philippine pesos.
Yeah, that's a significant amount, and this is where the case really brings to light all the complexities of dealing with input VAT, particularly for businesses that have a mix of zero-rated and VAT-able transactions.
And just so everyone listening is on the same page, the Court of Tax Appeals, which we often shorten to CTA, is this special court in the Philippines, and they handle, you guessed it, tax disputes. In this case, get this, it went from the CTA division all the way up to the CTA on bank. That means all the judges on the court had to hear it before finally landing in the lap of the Supreme Court of the Philippines.
The fact that this case went through, like, the entire Philippine court system, it just shows you how important these legal issues really are.
Okay, so let's back up a bit here. We need to make sure we all understand this whole zero-rated sales idea. So DKS, they're saying that some of the services they offer, especially the ones they do for companies outside the Philippines, should be considered zero-rated. So what exactly are we talking about when we say zero-rated sales in the Philippines, and why would a company really want their services to be seen this way?
You've hit on a really important point there. In a nutshell, zero-rated sales are transactions where the VAT is, well, 0%. But here's the catch. It doesn't mean the company itself doesn't have to deal with VA at all. They still got to pay VA on their inputs. Those are the goods and services they use in their business. However, because what they're selling, their output, is zero-rated, they can't charge V8 to their customers.
So they end up basically eating the cost of the V8 they already paid. That doesn't sound very good for business.
And that is exactly where the V8 refund comes in, because they've already paid V8 but haven't collected any from their customers. Businesses doing zero-rated sales can often apply to get that input V8 defunded.
So it's kind of like the government is saying, we get it. You already paid V8, so we'll give you that money back since you couldn't charge your customers for it.
Exactly. And that's what GKS was trying to do. They paid a good chunk of change in VAT on their inputs. And since they saw their services to these foreign companies as zero-rated, they wanted a refund. But, and I bet you can guess what's coming next, the tax authorities in the Philippines, the BIR, they took a really close look at DKS's claim. And that's where the real story begins.
Sounds like this whole case comes down to two big questions. First, are the services that DKS provides actually zero-rated sales? And second, if they are, how much of that input VAT can they actually get refunded?
You hit the nail on the head. And as we get into the arguments from both DKS and the BIR, you'll see how those simple-sounding questions can get really complicated really fast.
So we've got DKS claiming they should get a VAT refund on what they're calling zero-rated sales. And we've got the BIR looking really closely at whether those sales actually count and how that refund should be calculated. So let's dig into the specifics here. What were the BIR's biggest issues with DKS trying to get this refund?
Well, the BIR's main argument at the beginning had to do with DKS's documentation, or rather whether it was complete. They were saying that for a sale to be considered truly zero-rated, a company needs to prove without a doubt that the customer receiving the service is actually outside the Philippines. And on top of that, they need to prove the service itself isn't some kind of exception to the zero rating rule. The BIR didn't think DKS's paperwork was strong enough in that sense.
So it's not like they were saying DKS's services didn't count at all. It was more about proving that those services really fit the rules for being zero-rated, right?
Exactly. Think of it like a trail of breadcrumbs, but instead of leading to Hansel and Gretel's gingerbread house, they lead to proof that a sale should be zero-rated. The BIR wanted to see a clear connection every step of the way between the services DKS provided and why they qualified for zero rating. They were saying this detailed documentation is super important to keep the whole VAT refund system from being abused.
And that makes sense. Like, it's a way to stop companies from saying their sales are zero rated when they're really not and trying to get money back they shouldn't. But what did DKS say about all this? Did they just admit they messed up their paperwork or did they push back?
Oh, DKS pushback for sure. They argued that they had submitted everything that was needed. This difference of opinion over what complete documentation really means became a huge point of disagreement in the case. But it's important to remember, this wasn't just about paperwork. What was decided here would directly affect how much money DKS got back and, even bigger, how VAT refunds are handled for everyone in the Philippines.
And that's where the Court of Tax Appeals comes in, right? They're the ones who had to look at everything and figure out who was right according to the law. So what did they say?
Well, the CTA division, that's the first level of the Court of Tax Appeals, they actually sided with the BIR. They agreed that DKS hadn't given enough proof to back up all their claims about zero-rated sales.
So round one goes to the BIR. But I know this wasn't the end for DKS. Tell me more about how this case went up to the CTA en banc and then all the way to the Supreme Court. What were the big moments along the way?
This is where it gets juicy. DKS was not happy with the CTA division's decision, so they appealed to the CTA en banc. Now, when a case goes en banc, it means all the justices on the Court of Tax Appeals get together to hear it and make a decision, not just a small group. This doesn't happen very often, and usually only for really complex cases or cases that could affect how taxes are managed in the Philippines in a big way.
So basically, DKS was asking for a do-over with all the tax experts. Definitely a sign that things are heating up. So what happened?
The CTA en banc kind of split the baby. They overturned part of the earlier decision, saying DKS was right about some things, but they still agreed with the BIR on other points, so DKS didn't get everything they wanted.
A partial win for both sides then, but nothing really settled. No wonder it ended up at the Supreme Court. But before we go there, I think we need to talk about something the Supreme Court clarified that's really important. How businesses that have both zero-rated and VAT-able sales, like DKS, should handle their input VAT. What's the gist of that, and why is it such a big deal in this case?
You're spot on. This clarification from the Supreme Court is huge, especially for businesses like DKS that have to deal with this mix of VAT situations. What they said is companies in this position have two choices when it comes to input VAT. They can either use it to offset their output VAT first and then try to get a refund on whatever's left over, or they can go straight for a refund on the input VAT that's directly tied to their zero-rated sales.
That sounds like a pretty big change in how input VAT is supposed to be used. Why is that such a big deal? What does it mean practically for businesses?
So this is really a win for businesses in DKS's position, right? It's like they're finally being given the choice to decide what to do with this V8 instead of being forced into one specific way of doing things. Exactly. You've got it. That's why this clarification is so important. By saying there are these two options, the Supreme Court is acknowledging that businesses dealing with both zero-rated and VAT-able transactions have a unique situation, and it gives them more flexibility, which could even mean more money in their pockets.
I see what you mean. So instead of having to use input V8 to offset output VAT first, even if that means a smaller refund, DKS and businesses like them can now directly get back the input VAT they paid on those zero-rated sales. That seems like a pretty big deal for managing cash flow and making sure you're not losing out on potential tax benefits.
Huge. Think about a business that does a lot of exporting or international services. This ruling lets them get back the input VAT on those zero-rated sales much faster, and that can make a real difference in their financial planning and how much profit they make.
It just goes to show how important it is to really understand these regulations and get good tax advice, right? Something that seems like a small technicality can actually have a big impact on a business's bottom line. But let's get back to DKS. Did this new way of looking at input VAT actually play a role in their case?
Absolutely. That's exactly why DKS ended up with a bigger refund than the lower courts had initially given them.
Wow, so even after all the back and forth, the scrutiny of their documentation and the appeals process, DKS actually ended up in a better position than when they started.
That's right. And it shows why it's so important to fight these cases, even when you're dealing with a complicated legal system. This DKS case, it reminds us that tax law, sure, it can be tricky, but it also can offer up some unexpected opportunities if you know what you're doing and have the right people in your corner.
I think you've hit the nail on the head. Persistence, good record keeping, and solid legal advice. Those are the big takeaways here.
And don't forget about staying up to date on changes in tax rules. What might have been okay yesterday could change tomorrow, like we saw with this decision on input VAT.
So for everyone listening who might be thinking, this is great for big companies like DKS, but I'm just a small business owner,
Hmm.
what does this case mean for them?
These principles apply no matter how big your business is. Whether you're a small shop or a huge corporation, really understanding Philippine VAT law, especially the parts about zero-rated transactions, is crucial. This case proves that getting good advice can help you find ways to maximize your VAT refunds and come out ahead.
Like we always say on this show, it's all in the details, and those details can make all the difference when it comes to taxes. Any last thoughts before we wrap up our deep dive into this fascinating case?
I think this case should encourage businesses to be proactive. Don't be afraid to get help understanding how these laws affect your specific situation. You never know what you might find out.
Well said. And on that note, we'll wrap up our look at the ins and outs of Philippine VAT law with the landmark case of Commissioner of Internal Revenue versus Deutsche Knowledge Services. Remember, knowledge is power, especially when it comes to taxes. Until next time, happy filing.